Through Siaya Senator James Orengo and Paul Mwangi, the opposition, which was enjoined in the appeal as the sixth respondent under the National Super Alliance, made its submissions as they tried to persuade the five-judge bench at the Court of Appeal to uphold the April 7th verdict that barred IBC from verifying the presidential results received from the 290 returning officers before declaring the winner.
You have to look at the spirit and the objects of those particular provisions. You cannot just look at it as a dry statement of the law.
Orengo seeking to demonstrate before the court that a re-verification of constituency presidential results at the national level could create loopholes for results tampering.
If there was some intervening action by the Electoral Commission from the moment the votes are announced and declared at the constituency level, there should have been another form that would then be signed by the chairman of the Electoral Commission or some super returning officer showing that the changes that were made by the Electoral Commission. There is no such opportunity for the Commission or its chairman to do that.
There is no form of declaration that is signed. That form, my lords, is entitled Declaration of Results for Election of the President of the Republic of Kenya at the National Tally Center. And if you look at the end of the form, it is signed by the chairperson of the appellant, and he is required, other than to append his signature and the date, he is also required to append his ID number. That form exists.
In their submissions, they poked holes into the appellant's arguments, seeking to have the High Court judgment nullified on grounds that it erred in law, with the point of contention being Article 138 of the Constitution, as well as Section 39, 2 and 3 of the Elections Act that provides guidance on the tallying of presidential results.
We have the wrong electoral officials. They are officials that were picked by IEB itself. It sets the standards, it sets their qualifications, it sets the recruitment processes, and yet come to court to say that despite the fact that they are the ones who recruited them, this court has to deal with the fact that they will be both incompetent and ineffective and fraudulent.
High Court judges Chacha Mwita, Agre Muchelule and Weldon Korir ruled that any dispute on the constituency presidential tally can only be challenged in an election court, a finding which IBC argues will potentially sink the country into chaos. During the two-day hearings, the five-judge bench appeared not to entertain sideshows in the courtroom, arguing that the legal issues under consideration were complex and of considerable public interest. The judges have now retired to consider the appeal and will deliver their judgment on the 23rd of this month, with the possibility that the matter could end up at the Supreme Court, whoever weighed the judgment. Ben Chumba, reporting for Channel 1 News Hour.